So welcome to the Data Explorers Update with me, Will Duff-Gordon. So normally we cover a subject slightly different to the one we're going to cover today, which is we're going to look at the legal and tax side of securities lending and borrowing, which we know is an incredibly important aspect and one we don't cover often enough. So we're delighted to be joined by Adam Blakemore from the law firm Cadwalader, because in the UK Supreme Court, the former House of Lords, there was quite an interesting case affecting securities lending and repo just before Christmas. And that does cut to some pretty important implications, does it not, as to how people are engaging in transactions that are perhaps not covering a short sale, should we put it like that?
That's right. Thank you very much, Will. The case was heard in December of 2010, so it's very recent indeed. And although it was about a repo transaction, I think the legislation for stock loans in the UK and the taxation of stock loans is not dissimilar from the legislation from repos. And I think that the case has a number of important consequences and important lessons as regards structured transactions where there is a tax element in there and that the tax saving or tax planning is an element of the overall transaction structure.
So it sounds like from the summing up or the wording as a result of this case that you've got to be quite careful entering into a transaction where you're maybe claiming a loss in order to make a profit in the end.
That's exactly right. Great care is needed in transactions just generally, and where there is any tax arbitrage or tax planning, then obviously tax advisors look very carefully about that, whether that arbitrage works or not. So in this particular case, there was an economic loss of around about £1.8 million sterling which was suffered. But because the wording of the legislation, which was very closely written, very detailed, and had gone through a number of different permutations over about 5 or 6 years, the actual loss which was claimed by the taxpayer was in the region of £28 million. So there's a very clear asymmetry between the economic loss suffered and the tax loss produced. And what the Supreme Court said was that in those circumstances, they want to really try and find a symmetrical position and interpret the legislation and the purpose of the legislation as really creating a commercial symmetry so that commercially absurd results wouldn't be respected. So the court probably got to a sensible position there, but the process through which they did that has a number of important consequences.
But the bottom line there was that about asymmetries and symmetries, that you cannot necessarily. Whereas before, it's always been slightly illogical to the court, but the courts haven't made this argument before, which is, hang on a second, we're now going to look at every transaction, and if you are essentially doing a transaction that loses money here in order to make money here, that we're going to look to basically stop that kind of transaction happening.
Yes, I mean that's certainly one element of it. I mean, what the courts have always looked at is they've looked at the purpose of legislation, taxing legislation, and they've tried to find out the purpose for which Parliament has enacted the legislation. They've also tried to look at the transaction, as they say, viewed realistically. So they want to really find out what's going on. But the approach that the court took in this particular case was to look at very closely written legislation which produced a technical result. And I think it's important that the Supreme Court has gone on to say, well, in those circumstances, if what you end up with is a bizarre result or commercially absurd result, as the law lord said, in those circumstances, I think we can expect that the court's going to err on the side of ensuring that an asymmetrical tax loss, for instance, isn't going to be allowed. And that's got important consequences for all tax planners.
Yeah.
Now, stock lending, most of the transactions, 95, perhaps even more, percent of the transactions in the stock lending world won't be motivated by tax avoidance. But the ones where tax plays a component part and an important part, perhaps in one of the parties' tax plannings, in those circumstances where that transaction in the UK, they need to look quite carefully.
So finally, this was not just an isolated. The precedent's been set here. Is it going to have a European context to it? I mean, this is what's happened before Christmas. It's not something that is a sort of one-off, is it?
It's probably not a one-off. I mean, the courts have looked at tax transactions or taxing transactions where avoidance has been present for decades, really. Yeah. So it's an evolving context. It's not a European decision of the European Court of Justice. There are different cases in the European courts which look at how tax avoidance is is judged and in the context of those particular transactions. But this is really just affecting people in the UK. But that's not to say that in other jurisdictions there aren't similar cases
That's
decided
right.
along those lines.
So there could be some more news, and if we hear of any, or if anybody is aware of anything particularly significant in this area, do get in touch, because we definitely want to come back, I think, a bit more often to what's happening on the documentation, legal and tax planning side, because it's a really crucial. Well, Adam, thanks very much for coming in.
It's a pleasure.
If you'd like to read the full report, it is in the usual place, dataexplorers.com/news, and if you have any more pinpointed questions, then we can put you in touch with Adam directly. So thank you very much, and we will talk to you again tomorrow.